Hi, this is Erica Merrill, and I am the founder of Perfect Legal Video. I am very excited to have with us today Attorney Jim Sorenson. He is a partner at Sorenson Van Leuven out of Tallahassee, Florida, and they represent credit unions. Welcome to the show today, Jim. Thank you so much for joining us.
Erica, thank you so much for having me. It's good to see you today and good to talk with you, and looking forward to our discussion today.
Fantastic. Me too. So let's get to the first question. Let's talk about reaffirmation agreements and, just can you define that for us and just remind us what it is?
Yes, so a reaffirmation agreement is a voluntary agreement whereby a debtor in bankruptcy, and their creditor agree that the debtor will resume or continue paying a debt even though that debtor has filed bankruptcy. And once that reaffirmation agreement is final, it results in the debt not being discharged. In other words, the debt is taken out of bankruptcy and the debtor still owes that debt. So it's a voluntary agreement to repay a debt, notwithstanding the bankruptcy filing. And the reaffirmation agreement is completed using court-approved forms. So years ago, you used to be able to use your own forms, and several years ago, the court went to a standard form for doing what we call a reaffirmation agreement.
And that makes sense. And this is part of your series that we've been doing, having to do with myths and misunderstandings. And so if you could just lightly go over what the myths and misunderstandings are, that would be wonderful.
So we have been taking this opportunity to highlight certain myths and misunderstandings out there in the credit union world. And this time I wanted to focus on misunderstandings regarding reaffirmation agreements. And so there are several. One is the debtor's right to reaffirm. When do they have a right? Do they always have a right to reaffirm? Two is, what about if you want to modify the loan as part of a reaffirmation agreement? There's some myths and misunderstandings regarding that. And then the time for actually filing the reaffirmation agreement with the court. How does that work? What are the time requirements? The debtor's ability to rescind or back out of the reaffirmation agreement. And then finally, just the credit union's options if the debtor defaults on a reaffirmation agreement. What are the credit union's options? And what I find in my 25 years of doing this is there's a lot of just misunderstanding and sometimes myths about how this works.
It sounds like a million things could go wrong. Why don't we start with the debtor's right to affirm? Can you let us know what is the myth on that topic?
Yeah, so in short, what we run into and what we see is there's often a misbelief or a misunderstanding that the debtor has an absolute right to reaffirm a debt. And that is not the case. The law is absolutely clear on this, that a reaffirmation agreement is a voluntary agreement that both the debtor and the creditor have to voluntarily make. In other words, one party cannot force the other party into the agreement. And so, for example, let's assume we have a debtor John Doe or debtor Mary Doe who has an outstanding claim with the credit union. And it involves two loans. One is an indirect auto loan and one is a credit card. The debtor can propose to reaffirm the indirect auto loan and say, I only want to reaffirm the indirect auto loan. I do not want to reaffirm the credit card. Let's assume in this example that they are current on the auto loan. Their auto loan is paid up to date. They haven't been in default. They're wanting to reaffirm pursuant to the original contractual terms. The credit union can reject that proposal. The credit union can say, we are not going to agree to enter into a reaffirmation agreement of the indirect auto loan unless you also enter into an agreement on the credit card. what a lot of people assume, and goes back to one of our previous conversations about miss, is that the reason you can make that you can take that position or reject that reaffirmation is because of the cross-collateral clause. But as we covered when we talked about cross-collateral clauses and the miss around those, an indirect auto loan does not have a cross-collateral clause. So the reason the credit union can reject proposal has nothing to do with the cross-collateral clause. It has to do with the fact that the credit union cannot be forced into a reaffirmation agreement. So the debtor can propose something and the credit union has the option to agree or disagree, and vice versa. The credit union can propose something and the debtor can agree or not to agree. It is purely a voluntary agreement that the parties have to come to.
And that makes a lot of sense. And so I can see where it's confusing. It's funny how if you miss one little thing, like the absence of the cross-collateral clause, that can make all the difference. Do you see that happen a lot?
Yeah, I think there's things get because the law can be so technical, and then when we're talking about bankruptcy is one of the even more technical areas of the law. It's one of the most technical areas of the law that a lot of times these other side issues come in, like a cross-collateral clause, and they confuse or cloud the issue, and sometimes people make it more complicated than it really is. And so that's why I want to highlight that the reaffirmation agreement, the debtor can propose whatever they're going to propose, and the creditor has the option to accept or reject or make a counter proposal.
I mean, that is absolutely interesting. So let's talk about the second myth that we were going to cover today, which is, can the creditor modify a loan as part of a reaffirmation agreement?
Yes, the creditor can modify the loan as part of the reaffirmation agreement. They can choose to modify their interest rate, so they could reduce the interest rate if they want to. They could modify the payment or the term of the loan, the length of the loan. They could even agree to reduce the balance owed. And that's done often in the credit union world. The myths that come up are really two myths related to this. First, there's a belief that the modification of a loan through a reaffirmation agreement has to be done pursuant to the credit union's loans or lending policies. And that isn't true. In making a reaffirmation agreement, the credit union is not making a loan. The loan was already made. They're simply trying to keep that loan from being discharged in bankruptcy. So really the decision on when and how and in what to do in terms of a modification is not going to be governed by your loan policies and procedures. It's going to be covered by your loss mitigation policies and procedures. And that is, a lot of times we see that misunderstanding in the credit union world, that we'll suggest to a client that, hey, maybe you should consider in this situation reducing the interest rate, reducing the payment. And the response we get a lot of times is, well, our loan policies don't allow that. Well, again, we're not making a loan. We're trying to keep a loan from being discharged. The loan was already made. So that's myth number one. The second myth that comes up is that, and this has to do with the documentation of the modification. In a non-bankruptcy situation, if a borrower is having trouble paying a debt, the credit union will oftentimes offer the borrower a workout arrangement. They may agree to reduce the payments, lower the interest rate. They may move a due date. There's different approaches to working with a member. And so in those non-bankruptcy settings, they will usually use a modification agreement or another form commonly used in the credit union world as a subsequent action form. And those forms are simply used to document the agreement. The credit union agreed to reduce the interest rate and reduce the payment, and the debtor signs off on that. What happens is when the reaffirmation agreement gets done and it shows a reduction in interest and a reduction in payment, often I have the client saying, well, they need to sign a subsequent action form as well. And they don't. The reaffirmation agreement serves as the document that evidences the modification. It has all the terms contained in it. It has the disclosures required. There is nothing from a legal standpoint that you have to have them or need them to sign a second or additional paperwork. You're just creating more work for yourself. And in some cases, what I find is you're creating confusion, because the reaffirmation agreement is very detailed in what has to be provided to the debtor or borrower. And then you have this other form that gets used, and it may not get filled out correctly or completely, and it just adds confusion on down the road. So the myth is the reaffirmation doesn't serve the same purpose as the modification documents. And I want to make sure we clarify that today.
I mean, and that's good. It sounds like this is a great case for having a checklist and a process so that you don't end up missing this kind of things. And I know that is one of the things that needs to be trained over and over. And that is something that you help provide for your clients.
Yes, Erica, you know me well. When you say checklist and process, you're speaking my terms. These are things that I some of my clients would tell you I maybe say those words too often, but they're true. Without good checklists, without good processes, the system can break down. And so you do have to have that training. You have to have those detailed processes or those checklist workflows that help you guide you through these circumstances, because it can be tricky, and things, if you're not doing them all the time or you have new people filling in, these aren't things that people intuitively know. So that is very important.
Well, that's good to know. And you're right. I mean, I hear it all the time, but it is so important, because honestly, it can save you and your credit union tens of thousands, hundreds of thousands of dollars, maybe millions. It just depends on when someone starts making a mistake, it tends to become part of their process. I mean, that's the big nightmare, when a mistake becomes part of the process and you are working with thousands of clients. That's where you can run into huge trouble.
That's correct.
So let's talk about timing, because timing is everything. And that's one of the things that we want to point out here about a myth or a misunderstanding about the timing for filing a reaffirmation agreement with the court. When does that reaffirmation agreement have to be filed with the court?
Yes, to be effective, the reaffirmation agreement must be filed with the court before the debtor receives his or her discharge order, and it must be filed by the deadline that is set out in Rule 4008. This is the bankruptcy rules of procedure. And that rule sets the deadline as no later than 60 days after the first date set for the meeting of creditors. So there is a specific deadline. And what I find often is people assume, or people incorrectly believe, that the deadline is, well, I just need to file it with the court before the bankruptcy case is closed. And the reality is that this deadline, the 60 days from the meeting of creditors, is often a month or several months before the case is closed. So a late filed reaffirmation agreement is not effective, and treating it as such can be a potential problem for the credit union, could lead to liability. So knowing the rule, knowing the timing and when and how it has to happen is very important.
I agree with you, because I don't know about you, but you miss a deadline and you're like, oh, I should have written that down. And then all of a sudden there are fees or the possibility that you can't do what you wanted to do. And I mean, that's the most frustrating thing, when you miss it by a few days or a week, and then all of a sudden the consequences for that are just exponential. And so, I mean, I'm glad that you mentioned that. Now, one of the things I was surprised to see in the questions today was something about the debtor being able to rescind the reaffirmation agreement. I mean, I guess we're going to clear this myth up today.
Yes, so the debtor does have the ability to rescind an agreement, but the myth or the misunderstanding is probably twofold that I commonly see. One is, how long does a debtor have to rescind the agreement? There's confusion about this. So here's another deadline, here's another time frame. And then, what is required by the debtor to rescind the agreement? There's a lot of confusion and misunderstanding about that, and the bankruptcy code is pretty specific on when and how that must happen.
So just so that those out there are looking to do that, or the credit unions are really looking to make a note of this, how long do they have to rescind an agreement?
Yeah, so the debtor has, under the bankruptcy code, the debtor has until the later of, and here's where the confusion comes in, because it's the later of. So you've got two deadlines and two date points, if you will, and you've got to pick whichever is later. And so it's the later of either the date before the debtor receives their discharge order, or within 60 days of the reaffirmation agreement actually being filed with the court. So what you first have to do is say, okay, when did the reaffirmation agreement get filed with the court? Well, it got filed on July 1st, let's say. So you would then go out 60 days from July 1st and say, okay, we know they have until that 60-day period, and let's just say that is going to be August 29th, with the 31 days in July and 31 days in August. I think that with 60 days is, I don't have a calendar in front of me, but I think it's August 29th, so we'll say that's it. So we know they have at least until August 29th. And now the second point comes in, which is, okay, they have up until the day before the discharge is entered by the court. Well, a lot of times we don't know when the discharge is going to be entered by the court until it actually happens. And so we have a general idea of timing, but normally it is going to happen 60 to 70 days after the meeting of creditors is concluded. So when we look at that, we have a good idea and we can say, okay, here's the later of the two. And that is when the debtor has until to actually rescind or back out of the agreement. And often people just think it's the 60 days. That's all they focus on, is the 60 days. And depending upon how that other date is working, you may pick too early of a date. And if a debtor does rescind or tells you they're going to rescind, then you believe they're outside the time period, when in fact they're inside the time period. So again, it's very complicated, and this is where having a good, clear procedure with good training becomes so important, so that the person working at the credit union understands how these time periods work.
Oh, I agree with you, and it sounds like they have plenty of time from what you've talked about here. So I mean, if they're gonna do it, there's really no excuse if they miss that deadline other than not knowing. But I mean, at least the credit union should be informed of what needs to happen and when, and that way they can see that agreement as fully in place and that it's not going to change. So that's really great. So how does a debtor go about rescinding an agreement?
Yeah, so the bankruptcy code only requires that they give notice to the creditor. Then the notice doesn't have to be in writing. What the misunderstanding or the myth is that it has to be in writing. So they literally can call up a creditor and say, I'm not going to pay on that reaffirmation agreement, or I'm backing out of that reaffirmation agreement. As long as what they're saying is clear, that they're not going to abide by it anymore, and it's within the time period allowed, then that is a rescission. And so the credit union has to understand that, and obviously if it does happen in a phone call or a conversation with the borrower, document their file accordingly to capture that communication from the member. Now, obviously, if you are representing debtors in this case, and debtors lawyers that I know will tell their client, hey, if you're going to rescind, put it in writing. And certainly writing is the best evidence of it, but the law doesn't require that. And so I want to just make sure that credit unions understand this. The law doesn't require it to be in writing. So if it's a verbal rescission, that is sufficient under the law.
Wow, that might be the first time I've heard that. Usually in law, they'll write it down, keep a journal, all the things that have to do with really proving what you need to prove later on by keeping things in writing. So, I mean, that is definitely good to know. I'm sure this happens because people do have the best intentions, that occasionally they might do a reaffirmation agreement and then unfortunately still default on the loan. What options does a credit union have if this occurs?
Yeah, so this is another area where there's misunderstanding, and it does happen. It doesn't happen a lot. I would say most of the time, if a debtor reaffirms, they pay the debt and then they move forward. Of course, and the reason for that is the bankruptcy often eliminates other debt they no longer have to pay for. So when they come out of bankruptcy, they're in a better financial position. So paying for the credit union's loans is a lot of times easier, fits better within their budget. But that's not always the case. And there are times where situations unfold down the road that were unexpected and they default on the loan again. And so then the credit union gets into, well, what can I do? And a lot of times we see confusion about this. Ultimately, if they fail to pay the debt, the credit union has the ability to treat that debt as if the member never filed bankruptcy. What the reaffirmation does is it cancels out the bankruptcy as to that loan. And so if they don't pay, the credit union has all its remedies that it would have had the bankruptcy not been filed. So they can bring a lawsuit, they can recover their collateral, they can assign it to a collection agency. All of those things still exist.
That sounds very interesting. So can you tell us, I mean, it sounds like there's a lot of moving pieces here. So what can a credit union do to help its employees understand reaffirmation agreements, along with the importance of getting it right the first time?
Yeah, so we hit on this before, but I'll say it again. I mean, the credit union has to have well-established, clear procedures that address the use and the scope of a reaffirmation agreement. That can include and probably should include checklist, maybe a process or a flow chart of how this works. People comprehend this information in different ways, so all of that is important. I think, too, having training on these issues, on reaffirmation agreements and other complicated bankruptcy issues, having regular training, because some of these things happen often and some don't happen as often. And the things we tend to forget are the things we don't see all the time. So something you haven't dealt with in 9 months comes up, and an employee's unsure. Do I remember that right? Do we have that right? If your procedures and your documentation don't clarify it, then they're left having to guess or to rely upon a lawyer, and hopefully they're reaching out to get clarification in those situations. So, and then finally, one of the last things that I recommend, and this is more of a practical approach, is I recommend that a credit union in their collections department in working these reaffirmations is actually have a queue set up where loans that have been reaffirmed are put into a queue, so that if they do fall delinquent, they are clearly identified. And this is important, especially during the rescission period. So, as I indicated earlier, the debtor has at a minimum 60 days to rescind the reaffirmation agreement or to back out. And during that 60 days, of course, they could miss a payment. There could be some problem with the loan. And the credit union doesn't want to treat that like a normal loan. It's a loan the member has reaffirmed, but they still have the option and ability to rescind. So I usually suggest that those be handled in a separate queue. So and worked different. The process for working those is different. And so unless there's a way to identify those loans, the credit union runs the mistake of mishandling them. So that really is a practical situation. And of course, we can help with all of this at our law firm. We work with our clients in helping them establish clear procedures. We provide training or help them have useful training materials. And of course, we can help them with setting up the queues as I talked about. So these are all things we often work with our clients on.
I mean, and thank goodness, because I know that your clients love you for this, and that the proper training and procedures can really keep you out of a lot of hot water. So I appreciate your going over this with us today. I'm sure that the information is vital to our listeners, and you always bring something interesting. So thank you again for joining us, Jim.
Erica, thank you for having me. Good to see you today and good to talk with you.
Thank you so much. And I hope everybody out there listening has a great day. And thanks again. We will see you real soon.